Oh, hi. Hello, class. You're here already. Glad to see you made it. But you know me, I'm Patrick McGinley. I am your friendly neighborhood bar grievance defense attorney. And on Thursday nights, I'm also your law professor at your law school. It's a pleasure to be with you, even if it is just through this video camera. I regret that we couldn't be together in person today. But in this COVID-19 world of ours, I'm glad that we can all remain flexible. And I'm glad that the technology exists for us to touch base, even to virtually be together when those times make it impossible to get together face to face. I look forward to seeing you face to face in the lecture hall as soon as possible. But for now, thank you. Thank you for joining me here as I come to you live and in person via webcam from my library of my law firm here in Winter Park, Florida. So tonight we covered chapter 6 of our text called Analyzing Florida's Constitution. By now you're getting to know my textbook and my casebook and my writing style. At this point, I would very much welcome any feedback you're willing to share as to the quality, quantity of the cases that I've chosen to include for you, as to how well I edited them or failed to edit them well, if that's your opinion. Any feedback you have on writing style, presentation style is very much appreciated. This isn't the first book I've written. Lord willing, it won't be the last. So your feedback is something I would take to heart and implement in my future writing. So to the extent you're willing to share, I'm willing to listen, and I thank you for that. Speaking of willing to share and willing to listen, throughout the semester you've indulged me, you've given me the privilege, and it is a privilege, to begin each class with a prayer. I thank you for that, and I wish to indulge you one more time. As always, I'm not just praying at you, I'm praying for you. So keep those prayer requests coming. Also, to the extent that you join me in the prayer, then I'm not just praying at you or for you, I'm also praying with you. So feel free to join me. In the name of the Father, and of the Son, and of the Holy Spirit, amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, I fly unto you, O Virgin of Virgins, my mother. To you do I come, before you do I sit sinful and sorrowful. O Mother of the Word incarnate, despise not my petitions, but in your mercy hear and answer me. O Blessed Virgin, answer this prayer. I made a promise to this class not only to do a good job, but to not avoid the big issues that arise in their studies of constitutional law. In today's lecture, what we study, the right of privacy, big issues arise, such as medical care, such as the right to refuse medical care, such as the medical procedure we call abortion, such as euthanasia, such as sexting, such as so many things that have to do with our sexuality and our humanity. Grant my request, please, that I am always respectful of all other opinions, but at the same time, grant my request that I do not misspeak. I know the truth. I know that the teachings of the Catholic Church, as taught through its magisterium, are infallible, especially on the topics of which I will lecture today. Please do not let me misspeak. Don't let me say one sentence, one word, or one implication that contradicts my Catholic teachings that I hold dear. If it's your will, Lord, then I can do now what the Catholic Church has always done through its magisterium all day, every day. I can teach, and I can teach correctly. Amen. In the name of the Father, the Son, Holy Spirit. Amen. All right. Thank you again for indulging me. As I mentioned, we're up to chapter 6. We're talking about constitutional right to privacy. If you're joining me on paper, we're on page. Oh, time for the reading glasses. We're on page. Oh, look, the light shines in the reading glass. Isn't that cool? It's like I have now it's like I have two big bright eyes. Is that better? Maybe so. Okay, so we're on chapter 6. That's page 189. If you've bought the old-fashioned paper copy, I'm not sure how to find it if you bought the digital copy. But as I said, please buy the digital copy. Save a tree. Look at all the trees that must have passed away from all the books in this library, for example. Spare a tree. What's a tree ever done to you, right? So we're talking about privacy, and I begin with your current knowledge, the things you already know from having taken the prerequisite class of federal constitutional law. In that prerequisite class, you studied the federal right to privacy. And as I've mentioned in so many lectures before, the word privacy does not appear in the text of the federal Constitution. What you'll find as the lecture continues today is that the word privacy does appear in the text of Florida's Constitution. So there's one difference to note. Instead of arising from the alleged penumbras and emanations of the federal Constitution, when it comes to state constitutional law and Florida's Constitution in particular, we see that Florida's Constitution has a textual basis for a right to privacy because it is literally in the text of Florida's Constitution. But to begin at the beginning to what you already know, we compare and contrast different origins of the federal and Florida constitutional right to privacy here in chapter 6. And I begin with that World War I era case of Meyer versus Nebraska. Mr. Meyer was a school teacher, and he was convicted, a criminal conviction, for what he taught. And what is it that he taught? He taught how to speak the German language. He was a German language teacher. Why was this a criminal conviction? Well, in this World War I era, we were at war with Prussia or Germany, or gosh, I wish I were a better historian, but one of the German states, I believe. Oh, the historians are all after me right now. I'm trying to speak correctly. I've already prayed to speak correctly in this class already. Lord, come on, grant my request here, please. But anyway, so we're at war against Germany in World War I, and Mr. Meyer here in the USA is convicted of what was made a crime: teaching students how to speak German. But his criminal conviction was overturned, and in so doing, the Supreme Court of the United States cited the 14th Amendment to the U.S. Constitution and held, quote, "While this court has not attempted to define with exactness the liberty thus guaranteed, the term has received much consideration, and some of the included things have been definitely stated. Without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in the common occupations of life, to acquire useful knowledge, to marry, establish a home, and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized by common law as essential to the orderly pursuit of happiness by free men. The established doctrine is that this liberty may not be interfered with under the guise of protecting the public interest by legislative action which is arbitrary or without reasonable relation to some purpose within the competency of the state to effect. Determination by the legislature of what constitutes proper exercise of police power is not final or conclusive, but is subject to supervision by the courts." And through this holding, and then later expanded in places such as 1928's dissenting opinion of Justice Brandeis in Olmstead versus United States, and then later in cases such as Griswold versus Connecticut, we see that the Supreme Court of the United States created what did not exist in the plain text of the U.S. Constitution. The Supreme Court of the United States created a new constitutional right, a constitutional right to privacy. Ever since the Supreme Court of the United States created it, there has been many questions that needed to be litigated. Because when one creates a law through the democratic process, such as the U.S. Congress, where our elected officials who were specifically elected by us for the purpose of passing laws, when there are questions about such laws, we can go back to the Congress. They can amend the statute. They can clarify. They might even, at the time of creating the statute, delegate within appropriate boundaries some legislative authority to an agency which might have delegated and narrow discretion to help us with some of the questions that arise from a law. This is the great advantage to our democracy. Those advantages do not exist when a court such as the United States Supreme Court takes it upon itself not to interpret the law, but to create the law. When they are the creators of a law, we don't have a procedural means for doing what we can when Congress and a legislature creates a law. We don't have an agency within narrow boundaries to help us with the implementation and interpretation of the legislatively created laws when we're talking about judicially created law. And it disgusts me to say such a thing out of my mouth because it's such an antithesis to democracy to say judicially created law. But when it comes to what unfortunately is judicially created law, it is full of flaws in its interpretation and implementation because its origin wasn't through the traditional democratic process. So when we see decade after decade after decade of litigation about the right to privacy, well, we should have predicted that in the beginning, right? Because we didn't create those laws through the processes that have the safeguards that we so desperately need. Instead, when litigation creates a law, then it's more litigation that follows. Historically, that's always been true. Is that good? No. But is that true? Yes. So one of the things that I would hope would encourage judges to have judicial restraint. Lord knows judges need to have judicial restraint. One of the things that I hope encourages judges to have judicial restraint is when they look at the history of things that lacked judicial restraint, they see a history of litigation after litigation after litigation. They see a history of uncertainty. They see a history of the people not knowing what their rights are until more litigation arises and that more litigation is resolved. What is better, for the people to have known to them with certainty what their rights are, or for them to just wonder and wait and litigate and hope? Well, I guess that's a judgment call, but I guess by the way I ask the question, you can tell what my opinion is. So there's always that lack of certainty when it comes to things like these penumbras and emanations that allegedly create certain laws. We don't have that here in Florida when it comes to Florida's Constitution, when it comes to privacy, because the right to privacy is written in our Constitution. The people of the state of Florida enacted, voted, and passed an amendment to Florida's Constitution that specifically creates a right to privacy. In so doing, we have more confidence in knowing that it is the will of the people. So that's another advantage to democratically passed laws versus fiat, whether that fiat is from a lack of judicial restraint or from a king or from a dictator or whatever your source of fiat might be in a given society. Laws that come from fiat are constantly filled with doubt and arbitrary nature, whereas democratically passed laws, when done properly, are less filled with such flaws. So now let's take a look at part B of our text. Now we're up to page 193. We'll be looking at applying Florida's right to privacy. Now we see Article 1, Section 23 is where you can find the textual basis for this right to privacy. It embraces more privacy interests and extends more protection to the individual in those interests than does the federal Constitution, according to this quote that you see quoted here on page 193. As our lecture continues, let's put that assumption to the test, shall we? Let's find out whether that's true, and if so, what its limitations are. Let's keep an eye out for that particular question. Now, I quote also the elements of an action for a violation of right to privacy by the government. If you're going to allege that the government has violated your right to privacy and you're going to bring a suit, what is your burden of proof? What are the elements of that cause of action? What must you plead and ultimately prove in order to prevail against the government? And we have that here on page 193. The first element, you must prove state action. And that's an important element because the right to privacy under Article 1, Section 23 of Florida's Constitution is a right to privacy from the government, to keep private something from the government, unless you can show government action, a government actor, someone who acts on behalf of the government, then you cannot prevail under Article 1, Section 23. Now, there are laws, of course, that talk about other rights to privacy, and those laws may give you an actionable right against an individual who's not the government. For example, we all know that our current bank balance is a matter of privacy. Banking laws can make it actionable against the bank, who is not the government, if they violate those banking laws. But we're not talking about banking laws in today's lecture. We're talking about Article 1, Section 23 of Florida's Constitution. Likewise, another example, the federal government has passed HIPAA, the Health Insurance Portability and Patient Protection Act, if I remember exactly what the HIPAA stands for. But if you're done any type of work that is within the medical field or the periphery of it, certainly you're familiar with HIPAA. It is a patient privacy right when it comes to sharing medical information. Can you find a government agency who will fine a doctor or a healthcare provider who violates HIPAA? Well, of course you can. And that's true without government action. But again, that's because of that federal statute, HIPAA. Today, we're not talking about any federal statute when we talk about privacy. Today, we're talking about the plain text of Florida's Constitution, specifically Article 1, Section 23. So the first element of the action that you'll need to find is state action. The second element is a legitimate expectation of privacy. And as we continue in our lecture, we're going to look at cases such as AH, cases such as Burton, and they're going to help us define when, under Florida law, we have a legitimate expectation of privacy that is protected by Article 1, Section 23 of Florida's Constitution. The third element of the action is infringement upon that expectation of privacy by the state action. So the state has to be the alleged wrongdoer. You have to prove it was the state that did the infringement. And the fourth element, this, of course, because of the standard of review, the burden of proof, this goes to the government. Here we've got such infringement cannot be shown by the government to both protect a compelling state interest and achieve that protection in the least intrusive manner possible. Do those words sound familiar to you from Con Law 1 in your prior studies? Yes, they do. That's strict scrutiny, isn't it? Yes. And so once we've proven the prior elements, then the burden shifts to the government to meet that burden of strict scrutiny. That is a compelling state interest and achieving that compelling state interest in the least intrusive manner possible. So that, in a nutshell, summarizes what you'll have to plead and prove in order to hold the government liable for a violation of your constitutional right to privacy found in Article 1, Section 23 of Florida's Constitution. Florida's right to privacy has been found to protect the privacy rights of citizens from the unreasonable interception of communications. Similarly, the constitutional right of privacy undoubtedly expresses a policy that compelled disclosure through discovery be limited to that which is necessary for a court to determine contested issues. So, for example, say you're a lawyer, which I believe that's why you're here in law school today, right? Because you intend to be one. Say you're a lawyer and you happen to find yourself litigating. Maybe you represent the plaintiff. Maybe you represent the plaintiff on a contingency, by which we mean you'll receive no fees and no costs if no recovery. Obviously, you're interested in a recovery in such a case, are you not? But think about this. What if it's such a case where you don't know if the defendant has the money? The old cliche goes, you can't get blood from a stone or you can't get blood from a turnip. Either cliche is intended to mean if the defendant doesn't have money, then they can't give you money, right? So you might be curious as to whether or not the defendant has money. So as part of your discovery, be it deposition questions or interrogatory questions or requests for production of documents or things, you might inquire as to the financial status of the defendant. Maybe not. Article 1, Section 23 protects the defendant's right to privacy in this instance. Hey, wait a minute, I'm not the government, you might say. Correct. But by using the court system through litigation as a lawyer who is an officer of the court, you've heard it before, you are effectively using state process. Therefore, one of the things Article 1, Section 23 will protect a defendant from is discovery of that defendant's financial status. Are there exceptions? Yes, there are. And the exceptions were in the quote that I read to you. It says here, constitutional right to privacy undoubtedly expresses a policy that compelled disclosure through discovery be limited to that which is necessary for a court to determine contested issues. There's the limit of this rule. If it's necessary to get this financial discovery for the court to determine contested issues, then you can have discovery of the defendant's financial situation. To help you understand that, let me see if I can conjure an example. Imagine, if you will, that your contingency case involved a claim where the plaintiff, for example, alleges lost wages. Now, by making that allegation, the plaintiff has opened the door. The plaintiff has to answer a certain amount of financial discovery. The plaintiff is alleging lost wages. The defense has the right to do discovery to explore this claim that the plaintiff chose to assert. By the plaintiff choosing to assert it, the plaintiff made this necessary for court to determine a contested issue. The plaintiff chose the issue. The defendant contested it. Now we have a contested issue, and there is some right to financial discovery, at least insofar as necessary for a court to determine that contested issue. So as you go forth and become lawyers and litigate, Article 1, Section 23 will affect you when you're involved in that kind of litigation, and that's how it will affect you. Let's turn now to the first or the next case that we discuss in our textbook. This is the case of Winfield versus Division of Parimutuel Wagering, Department of Business and Professional Regulation. What's going on in Winfield? Well, we've got a Florida state agency called at the time Department of Business Regulation and Division of Parimutuel Wagering. What is parimutuel wagering? Well, it's not necessary for you to know for my exam, and probably not for the Florida bar exam, but roughly defined, parimutuel wagering is a type of gambling where the prize money arises from gathering up the bets, taking a vigorish or a cut out of the gathering of the bets to serve as the pay or profit of the gambling house, and distributing all the rest back to the players as their prizes. So parimutuel wagering involves no bank, if you will, by the house. The house gets its cut or a vigorish from the total amount of bets, and then the rest is returned to the bettors, not the same ones who paid it in. Instead, it's paid to the winners. It's not paid to the losers. But this is parimutuel wagering in a nutshell. Again, not on my exam, but good to know, perhaps. So the parimutuel wagering industry is regulated here in the state of Florida, regulated by that particular agency. In order to do its work, it is sending a subpoena, and it is asking for information of the bettors, those who bet. As you might imagine, if you want to make sure that the parimutuel house is doing things correctly, that they're keeping just the permissible amount of vigorish or cut from the parimutuel pool, you're going to have to audit their books from time to time, right? So naturally, the state agency has the power to do such an audit, send such a subpoena. But one of the bettors, person who placed the bet, is objecting. That's Winfield. Winfield says, hey, I have a financial right to privacy. Is Winfield right about that? Can you answer that question from what we've covered so far? Well, under Article 1, Section 23, yes. Winfield, as a Floridian, has a right to financial privacy under Florida's Constitution. Indeed, that's a difference between Florida's Constitution and the federal right to privacy. Winfield versus Division of Parimutuel Wagering explicitly holds that a Floridian has a financial right to privacy. That particular holding, as we speak today, has not yet arisen from any Supreme Court of the United States opinion. So when it comes to the SCOTUS, Supreme Court of the United States, SCOTUS creation of a federal right to privacy, SCOTUS has not yet acknowledged that its creation protects or extends to finances. There's not a financial right to privacy as of today in the Supreme Court of the United States decisions interpreting the federal penumbras and emanations that are the alleged source of the federal right to privacy. However, here in Florida, we have Winfield, which specifically holds that there is a financial right to privacy under Florida's Constitution. That's broader than the federal right to privacy. I'll read you the exact quote from the opinion. Quote, since the people of the state of Florida exercised their prerogative and enacted an amendment to the Florida Constitution, which expressly and succinctly provides for a strong right of privacy not found in the United States Constitution, it can only be concluded that the right is much broader in scope than that of the federal Constitution, end quote. Before I continue with the quote, to comment on that first part of the quote, is the right to privacy under the Florida Constitution broader than that of the federal? According to the Supreme Court of Florida in Winfield versus Division of Parimutuel, the answer is yes. You just heard the quote. If you want to argue that in court, you got an exact quote from our state's highest court that says so. So yes, you can argue with confidence that this has been held to be true, because I just read you the quote. Continuing now with the second part of the quote, I jump ahead a little bit, skip over about 2-3 sentences, and then quote, thus, we find that the law in the state of Florida recognizes an individual's legitimate expectation of privacy in financial institution records. Period. End quote. There it is again. I'm quoting to you from Winfield, from Florida Supreme Court. We don't have a quote like that from the United States Supreme Court. For that reason, I argue, and I suggest you should believe, that one way the right to privacy in the state of Florida under Florida's Constitution is broader than that of the federal Constitution is that Florida's Constitution creates a right to privacy in financial records. Oh, but McGinley, there's federal banking laws that certainly make banks keep my financial records private. Yes, that's true, but the source of that privacy is federal statutes passed by Congress and CFR, Code of Federal Regulations, administrative code regulations enacted pursuant to that congressional authority delegated in that congressional statute. Again, today's lecture is not to compare and contrast all sources of privacy. Today's lecture is to focus upon the constitutional right to privacy that arises from Florida's Constitution in its Article 1, Section 23, and to compare and contrast that right to the federal right to privacy that allegedly arises from the penumbras and emanations of the federal Constitution. So, in order to help you compare and contrast just those two sources, it should be noted that when the Supreme Court of Florida says that the Florida Constitution's right to privacy is greater than the federal Constitution's, this is one example that we can point to as to how that's true. So there you go. Now, after we talk about Winfield, which I put in the book to illustrate exactly how the right to privacy in Florida is broader than that under the federal Constitution. Next, I turn to a case that I intended to be an example for you of the limits upon Florida's right to privacy. This one is City of North Miami versus Kurtz. What's happening in Kurtz? Well, here we're interpreting Article 1, Section 23, and this is the question of great public importance that's being decided by the opinion. Does Article 1, Section 23 of the Florida Constitution prohibit a municipality from requiring job applicants to refrain from using tobacco or tobacco products for 1 year before applying for and as a condition for being considered for employment, even where the use of tobacco is not related to the job function in the position sought by the applicant? So what's going on here? Well, City of North Miami, at this time of this opinion, has decided to be self-insured when it comes to health insurance. They have an SIR, self-insured retention, of a certain level, which means they're going to pay out of pocket for health insurance costs until that SIR, that certain level, has been paid up. Think of it as like a deductible, if you will, the SIR. Once the City of Miami is paid out of pocket to the full extent of the SIR, then and only then does the reinsurance kick in and start to pay for health costs. Now, the SIR is quite high, so the reinsurance doesn't kick in until a high level. Therefore, the City of Miami is paying out of pocket and is quite interested in keeping its out-of-pocket expenses low. The City of Miami notes that one of the things that lead to health expenses is the use of tobacco. And as I join you today, we heard on the news yesterday that one of America's favorite cigar smokers, Rush Limbaugh, has lost his battle against lung cancer. So we know that it's obviously a serious addiction, nicotine, and it threatens our health, whether it's cigars like Mr. Limbaugh or cigarettes or what have you. And even those that want to quit can struggle to do so, right? Perhaps you've known a smoker, perhaps you've seen them struggle to beat the addiction. My point is, the City of Miami was able to identify that smoking leads to out-of-pocket healthcare costs, which is something they agreed to pay. So they want to hire non-smokers. Can they do that? Can they ask their applicants whether they're smokers? Ms. Kurtz said, can't ask me that. Ms. Kurtz filed suit. Ms. Kurtz alleges that we're violating her right to privacy under Article 1, Section 23 of Florida's Constitution. What is the holding from Florida's Supreme Court in this 1995 decision? The holding is quite clear. And the holding is that there is a limit. There is a limit to that right to privacy. It is limited. And I'll read you the quote. In, quote, determining whether an individual has legitimate expectation of privacy in any given case must be made by considering all the circumstances, especially, here's the key words, especially objective manifestations of that expectation, end quote. Objective manifestations. Now, that's what I'm trying to illustrate with this case. That's why I included it in the book, City of North Miami versus Kurtz. Let me take you back to a question we posed earlier, and I stuck a pin in it, so to speak, promised to get back to it. Remember, we were talking about the particular elements of a cause of action in Florida for a violation of Article 1, Section 23, right to privacy. One of them was, element number 2, is whether there was a legitimate expectation of privacy. McGinley, when is there a legitimate expectation of privacy? The answer to your question is City of North Miami versus Kurtz. The answer to your question is that quote. The answer to your question are those magic words. Objective manifestation. If an individual has a legitimate expectation of privacy, we can show and prove that through objective manifestations of that expectation. Okay, so there's your legal buzzwords, but let's implement them. Do we understand them? Let's see if I can conjure some hypotheticals that might help you understand them. In this particular case, right, we're talking about smoking. In this particular case, decided in the year 1995, I'm 49 years old, so I remember that year quite well. In 1995, when you walked into a restaurant, today, 2021, that's hard to do with COVID. But if you can remember, you used to be able to walk into a restaurant. You walked into a lobby, and that lobby, if it was a popular restaurant, was shoulder to shoulder, full of people. Certainly, whatever you said in that lobby was heard by many people. This is pre-COVID, okay? And what was the first thing back in 1995 after the host or hostess or seater asked you how many in your party? What was the very next question? Smoking or non-smoking? Do you remember that? And then based on your answer, whether you said smoking or non-smoking, they would walk you into the exact same dining room. The smokers and the non-smokers were in the exact same dining room. There was like an arbitrary, invisible line that the host, hostess, seater knew about and probably moved from time to time as to the smokers were over here, the non-smokers were over there. If there were booths in the restaurant, you know how booth backs might have seats that go back to back. You might literally have smokers on this side of the booth facing that table and non-smokers on that side of the booth facing that table. I mean, no social distancing there. So the secondhand smoke was all through the dining room, but still in that era, at that time in 1995, they'd ask you out loud, smoking or non-smoking, and what would you do? You'd answer in that crowded place, in that public place. Is there a legitimate expectation of privacy in a question that you routinely answer in public, out loud, in a public place? Likewise, during that era, if you rented a car, after some preliminary questions such as, what's your budget? What kind of model are you looking for? Do you want a two-seater or a four-seater? Do you want a two-door or a four-door? Do you want an SUV or a sedan? Then they'd ask you, back in 1995, smoking or not smoking, right? And again, in public, in a public place with that long line of people behind you, you would divulge that information. 1995, you're checking into a hotel room. After the preliminary questions, what did they ask? Smoking or non-smoking, right? And again, in the hotel lobby in front of everyone, you would divulge this information. What City of North Miami versus Kurtz found is that there was not a legitimate expectation of privacy in whether you're a smoker or non-smoker because of your objective manifestations. In everyday occurrences, in everyday society, you were constantly sharing with strangers out loud without being private about it, whether or not you were a smoker or non-smoker. Likewise, think of other examples, and when it comes to privacy, some of these issues get difficult. So let me begin with a difficult one, but a little easier than the ones we're about to get to. Let's talk about underwear. I'm talking about undergarments. I'm talking about not these outer garments, okay? Now, do I have a legitimate expectation of privacy as I sit before you in the webcam today for you to know whether or not I'm wearing a Navy suit? Do I have a legitimate expectation of privacy as to whether or not I'm wearing a striped tie? Obviously, the answer is no. But what about this? Do I have a legitimate expectation of privacy in you knowing, not just Bernadette, my wife, but you knowing whether I prefer boxers over briefs? Yes, I do have a legitimate expectation of privacy in that. Go ahead and Google me if you will. But so far, Lord willing, there's no evidence out there as to whether or not I prefer boxers over briefs. So I hope that funny example, at least I intended it to be funny, at least that funny example shows you what's meant by objective manifestations, right? So that's what we have under Florida's Constitution. Now, there's some notes and questions to consider. Note 1, to what extent does City of North Miami versus Kurtz acknowledge a greater right to privacy than found under the federal Constitution? Well, we certainly find a greater right explicitly in Winfield because the court so holds there. And maybe the same could be said when it comes to City of North Miami versus Kurtz. But as I mentioned on the outset, my purpose in including City of North Miami versus Kurtz was to show you what the legal standard is for element number 2 under the cause of action for a breach of privacy against the government based upon Florida's Constitution's Article 1, Section 23. Oh, my video just set offline. Are we still on? Hope there hasn't been a disruption in the video. Okay, I think we're back. Anyway, the point of City of North Miami versus Kurtz was to show you that a legitimate expectation of privacy can be proven or disproven based on objective manifestations. So that's your best answer for note and question to consider number 1. Note and question to consider number 2. If the Supreme Court of the United States issued a new decision disagreeing with its prior precedent and finding that there never was a right to privacy under the federal Constitution, then would a right to privacy still exist in Florida? And the answer is yes, because Florida has included in the plain text of the Florida Constitution a right to privacy. And thereafter, based on adequate and independent state law basis, there have been a multitude of decisions, such as Winfield that we discussed, such as North Miami versus Kurtz that we discussed, fleshing out the boundaries and the standards for that textual right under Florida's Constitution. So it cannot be said that Florida's constitutional right to privacy rises or falls based on the Supreme Court of the United States. There is an adequate and independent basis for such a right under Florida's Constitution that is bound in Article 1, Section 23, and the Florida state case law precedent interpreting that particular text. Note 3. A Florida Law Review article concludes that, quote, the state constitutional right of privacy in Florida extends protection no greater in scope than the minimum federal guarantee, quote. And that is a student-written note, appearing in an April 1995 issue, specifically volume 47 of the Florida Law Review. And it's just wrong. That's wrong. I'm sorry to disagree with our flagship university and its flagship Law Review, but it's wrong. They published something that's just legally incorrect. And we know that's incorrect because Winfield and Kurtz specifically hold or stand for the fact that it's a greater right under Florida's Constitution. We've already covered that. What are you going to believe, a Law Review article or the actual binding case law precedent from the state Supreme Court that is interpreting the text of the state's Constitution? I suggest the latter. Sorry, University of Florida and your flagship Law Review. You got a typo in there. Really should retract that. Now let's turn to part D. D as in dog. This is Florida's right to privacy and technology. Here we're talking about sexting. I told you, we tackle the big issues in this class. I'm not going to shy away from them. What is sexting? If you're unaware of sexting, then I'll give you a definition that you can find in a Law Review article. So I'm not turning to any smut to give you this definition. Instead, I'm turning to the First Amendment Law Review, Volume 9, page 99, 2010 edition. Sexting is defined as follows, quote, sexting, a combination, or portmanteau, you could say, but they said combination. A combination of the word sex and texting is a term coined to describe the activity of sending nude, semi-nude, or sexually explicit depictions in electronic messages, most commonly through cellular phones. While this behavior is perfectly legal and accepted among consenting adults, according to his Law Review article, juveniles prosecuted for this behavior end up being included on the public sex offender registry alongside the worst child molesters and pedophiles, period, end quote, according to this Law Review article. And to give you such an example, I've presented to you the case of A.H. versus State. Excuse me, got a little dryness there. Forgive me. So what's going on in A.H. versus State? What's going on is love. Two kids are in love. Kids can do stupid things. People who aren't kids and are in love can do stupid things. So kids that are in love can certainly do stupid things. One of the stupid things they did here was sexting. They were sexting one another. So they broke up, came to the prosecutor's attention after the breakup that the sexting had occurred. If you've got nude, semi-nude, or sexting pictures of a minor, what are you in possession of? You are in possession of child pornography. The possession of child pornography is illegal. Illegal. So these two kids were in possession of an illegal substance, that being the sexting photos, that being the child pornography. The defense attempts to defeat the criminal conviction and ultimately overturn it based on the allegation of a right to privacy under Article 1, Section 23 of Florida's Constitution. AH versus State is a 2007 decision of Florida's First District Court of Appeal and holds that the constitutional right of privacy does not prevent this conviction and will not be a sufficient basis to overturn this conviction. Just as the law review article said that juveniles prosecuted for this behavior end up being included on the public sex offender registry, this is an example of such a holding. AH versus State upheld the conviction, which in turn would result in the criminal defendant being added to the sex offender registry. What is the sexual offense of this minor? Sexting, being in possession of the resulting child pornography. So sexting is a serious issue. It's a serious issue for society. It's a serious issue for parents. It's a serious issue for children. Let's take a look at the notes and questions to consider. If you're following with me on paper, I'm on page 210 now, 210. Notes and questions to consider. Number 1, prosecutors in the state of Florida have discretion as to whether to bring criminal charges, even in cases where a criminal offense has occurred. Would the prosecutor in this case have been wise to exercise his or her discretion to decline to bring charges? If charges had not been brought, what harm to the public would have occurred? And note 2 is much shorter, but along the lines of the same question as note 1, so I read them together. Note 2, did the punishment fit the crime? Now, these are the kinds of issues that society must debate, must decide. There's often that legal concept of parens patriae, I believe is how the Latin is interpreted, that the government sometimes takes on a parental role. And perhaps that's what these laws were intending to do. But you know who else can take on a parental role? Parents. Parents can take on a parental role. We've studied throughout our semester, and it's a recurring theme throughout all my writings, this casebook being no exception, the Catholic social justice concept of subsidiarity. Subsidiarity is not the same as a subsidiary. We're not talking about a corporate parent or a corporate subsidy. We're talking about a different concept that sounds a lot like. Subsidiarity is that respect for levels of authority, that resistance of all authority being in one supreme or federal entity, and instead for lower entities, lower governments, be they state governments, municipal governments, or other organizations, to respect their authority, to allow them to coexist with the higher authority, indeed, to allow them to have some delegated authority, and to respect that delegated authority. Certainly, subsidiarity goes hand in hand with another Catholic social teaching subject, solidarity. Solidarity is the common good. We must implement subsidiarity with an eye toward the common good. We don't delegate authority to lower sovereigns in order to wash our hands of that responsibility. We must strengthen the lower sovereigns when necessary, aid them when necessary in properly implementing that delegated authority. That is part of the concept of federalism that we see in our national and subnational constitutions. That's part of the concept we see in having municipalities, that they themselves can pass ordinances and laws. And how does that apply here? Who's the best parent to parent these children? The municipal government, the state government, the federal government, the United Nations? Or is it mom, dad, grandma, grandpa, the first line of defense to our children being victims of sexting, and the first line of defense in preventing our children from engaging in sexting is us parents, right? So that's something to think about. And indeed, I had a quote from the Ave Maria Law Review, an excellent law review, in my opinion. Ave Maria Law Review. And again, this one was student written. He was a student at the time, is a lawyer now. I've never met the man. I hope I pronounced his name right. Joseph Paravecchia, Paravecchia. He wrote a 2011 Ave Maria Law Review article titled Sexting and Subsidiarity: How Increased Participation and Education from Private Entities May Deter the Production, Distribution, and Possession of Child Pornography Among Minors. This is note and question consider number 6. So I went from note 1 to note 2 and jumped down to note 6. But follow me here. I'm on pages 210 and 211. And a quote from Joseph Paravecchia's article says that provides a unique approach to the problem of minors engaged in the production and distribution of child pornography. Due to the problems associated with the prosecution of minors engaged in the act, non-governmental entities may be both in a better position to prevent minors from sexting and to do so more efficiently. To continue quoting, at the core of the notion of permitting the private sector to address the problem of sexting is the concept of subsidiarity. Pursuant to the theological component of that principle, when a decentralized entity, such as the family or a private institution, can effectively address a social concern, the sovereign state should allow it to proceed. Continuing the quote, no other entity can better communicate values and moral human development than the family, particularly the parents, period, end quote. And that quote is at page 238 of Attorney Paravecchia's article. What's your opinion on that? How do you feel? One of your assignments this semester, in addition to the midterm, which is coming up very quickly, in addition to the final that comes at the end of the class, is to draft your graded essay and hand it in to me at the time of our last lecture. Consult your syllabus for details, and I will have more details for you to come. But one thing to think about is subsidiarity. Do you agree or disagree? This could be the topic you choose to write about when it comes to subsidiarity, or any of the other topics you find as our lecture today progresses, or our prior lectures from a prior day, or our future lectures before we're done. Anything you find in our book, I believe, you can question and explore through the eyes of that Catholic social teaching subject of subsidiarity. And I would encourage you to do so. I look forward to reading your graded essays. Again, you don't have to agree with the concept. You can attack the concept. You don't have to agree with me. You can attack me in your essays. This is not indoctrination. This is education. Part of education is hearing ideas and concepts that ultimately you might reject. Maybe you'll become the world's greatest voice against subsidiarity. I hope not. But certainly that's an approach you can take in your essay. On the contrary, you can look at subsidiarity, such as the European Union has done. The Constitution of the EU specifically talks about subsidiarity. It's an issue that most certainly arises in our context of comparing and contrasting the national constitution with the subnational constitution in order to better understand and learn and interpret and analyze the subnational constitution. One way to do that is through the eyes of subsidiarity, and I encourage you to do so. Let me not neglect some more of the notes and questions to consider. Notes 4 and 5 are left, or 3, 4, and 5. Note 3, Judge Padovano's dissenting opinion compares and contrasts this case with Beebe versus State. Beebe versus State was where the Supreme Court of Florida held that minors have a right to privacy under the Florida Constitution when it comes to premarital sexual intercourse. Why would such a right of privacy extend to having sex, yet not extend to photographing it? Well, the easy question is that the easy answer to the question is that once we photograph it, when we're talking about minors, we're creating an illegal substance, a substance that is illegal to possess, a substance that is demeaning to not only those who are depicted in the photos, but to those who see the photos. The mere existence of child pornography is not only demeaning to the child, but it's demeaning to those who see it and demeaning to those who possess it. So its existence is trying to be stomped out by making it a criminal act to possess such a thing. That's the difference. That's the easier way to answer the question. The harder way to answer the question would be, well, why is there a state constitutional right to privacy for minors for having sexual intercourse? There are rules and regulations against it within the family, or most families. There are rules and regulations against it when it comes to statutory rape. So how on earth do we perpetrate the wrongdoing of having state law decisions say that it's a constitutional right? If it is to be a constitutional right, certainly it should be limited. It shouldn't, and it doesn't allow child pornography. It shouldn't, and it does not allow statutory rape. We know it has those boundaries and limitations. But the question society must ask, should there be greater boundaries and limitations? Note 4 reads as follows. Note the following criticism of Judge Wolf's majority opinion that appears in Judge Padovano's dissent. I got a lot of quotes in here. Quote, that the internet is easily hacked, as the majority says, is not material. The issue is whether the child intended to keep the photos private, not whether it would be possible for someone to obtain the photos against her will and thereby to invade her privacy. The majority states that the child placed the photos on a computer and then, using the internet, transferred them to another computer. Excuse me. As if to suggest that she left them out carelessly for anyone to find. That is not what happened, end quote. Judge Wolf's opinion was written in 2007. It was several years later that whistleblowers such as Edward Snowden alleged that our federal government often requires computer and laptop manufacturers who sell their products to install backdoor access into these devices. Is that true? Is that not true? Well, I got the quote here, and I've got a citation to an article, and you can follow the link to the web if you'd like. Is the web article correct? Is it not correct? That's not our point to explore today. Our point to explore is this. The dissent is arguing a flaw in the majority opinion. The dissent is not arguing per se a flaw in the outcome. The dissent is arguing a flaw in the logic. The logic of age versus state, the logic by which it yielded its outcome, is what's being attacked. That logic is that if you use an electronic device that's connected to the internet to store something, then you don't have a legitimate expectation of privacy, because the use of an electronic device that has internet access is an objective manifestation that you don't intend it to keep private. Now, wow. I hope you see the flaw in that logic from Judge Wolf's majority opinion in Age versus State that was written in 2007. Maybe times were different in 2007. Probably not when it comes to electronic devices. Just because you've got it on your hard drive, in your flash memory, in your storage on your electronic device, and just because that electronic device can access the internet, that doesn't mean that you expect the internet to see everything in your storage, your hard drive, or your flash drive of your electronic device. I don't think it ever meant that. It certainly doesn't mean that today. I don't think it meant that back in 2007. The dissent's attack of the majority's logic is sound. I'm not attacking the outcome. We have to quash and eradicate and eliminate child pornography. But their explanation of the fact that There wasn't a right to privacy simply because the child pornography was kept on a flash drive or a hard drive or a storage of a device, which in turn had access to the internet. That's certainly, hopefully, dicta. Because if it's not dicta, if that's the legal standard in Florida, then we've got some problems. And those problems are illustrated, well, I think, by Note 5. Note 5 says, similarly, technology has advanced after this 2007 decision to include an Internet of Things, or IoT, involving things like internet-connected lights, internet-connected doorbells, got a Ring camera, for example, internet-connected doorbell cameras, internet-connected music speakers, even internet-connected appliances, sometimes throughout the home. Many are run by devices such as Amazon Echo or Google Home, or I don't know if this is still true, Microsoft Xbox, which have internet-connected microphones listening at all times to the sounds and talk occurring in our homes. Perhaps some or all of these connected home or IoT devices can be hacked. The note in question then ends with this. Under the logic of Judge Wolf's majority decision, does a Floridian still have a right to privacy in such a connected home? And taking the logic on its face as something more than dicta, the outcome would be no, wouldn't it? So let's hope it's a proper interpretation of the logic of H versus state to say that it's mere dicta. Because if we don't say that it's mere dicta, then any electronic device that could access the internet, anything and everything stored on there is an objective manifestation that you didn't want to have it private. So you got a spreadsheet with your financial information on it. Is it on an internet-connected laptop? Is there such a thing as a not internet-connected laptop? Well, then, under this dicta, you wouldn't have an objective manifestation of privacy, right? Obviously, that can't be the accepted legal standard. So we've got to keep our fingers crossed that this logic of H versus state is dicta. And we also have to keep our fingers crossed that the outcome of H versus state is not, because we've got to root out child pornography. We can't have it. It can't exist. We've got to fight child pornography. Let's turn now from sexting and undergarments to even more difficult topics. Here we turn to Part E, beginning on page 211, Florida's right to privacy and refusing medical treatment. We're looking at Burton versus State. And in so doing, we take a roundabout way of looking at in re guardianship of Browning and in re Dubreuil. I hope I pronounced that name right. Dubreuil. Guardianship of Browning and Dubreuil are cited on page 212. And they're the more common cases to be covered in a Florida constitutional law case book. But I cover them both by covering this particular case, Burton versus State of Florida. So what is going on in Burton versus State of Florida? And what's going on there is the same lesson you would have learned from studying those other two cases of Browning and in re Dubreuil. Right here, this is an appeal from a circuit court order compelling a pregnant woman to submit to any medical treatment deemed necessary by the attending OBGYN or obstetrician, including detention in the hospital for enforcement of bed rest, administration of intravenous medications, and anticipated surgical delivery. Wow. So what's going on here? We've got a mom, and she has a birth plan. And her birth plan does not match up with what the OBGYN wants. So now who prevails? Mom and her birth plan, or the doctor, the obstetrician, the OBGYN, and the OBGYN's birth plan? For better or for worse, due to Article 1, Section 23's right to privacy under Florida's Constitution, it's the state of Florida that decides that, not the birth mom. If the physician follows the enabling statute created under the Florida statutes by virtue of Article 1, Section 23 of Florida's Constitution. What can happen is this. Under the statute, the OBGYN or the hospital where the OBGYN works can come to a medical conclusion that mom's birth plan is not in the best interest of mom's child. Therefore, the doctor can contact the state attorney, who in turn can contact the chief judge of the county circuit where birth mom is, who is to follow this procedure. The chief judge, herself or himself, or another judge of that circuit appointed by the chief judge, is to go to birth mom's bedside in the hospital and is to hold an evidentiary hearing right then and there. Hear birth mom's testimony and the testimony of the medical facility. And then right then and there, enter an order as to whether birth mom's birthing plan will be followed or the doctor's birth plan will be followed. Look at that procedure. Under that procedure, does birth mom have a right to an attorney, right to counsel? Well, not a free one. The state attorney is to get the judge involved to prosecute the case, but does not have the role of defending birth mom's interest in birth mom's possession or intention. Birth mom, I guess, if this is happening on a weekend in the evening while she's in labor, which is when it would be happening, can also pick up a phone and start calling attorneys on a weekend after hours and see who wants to rush to her bedside right now and put on a trial. I guess in theory, she might be able to find such an attorney, but in practicality, is that going to be easy to do? Practically, is that even going to be possible to do? I guess birth mom could just represent herself, right? That's due process of law. She could represent herself. Maybe even birth mom happened to have graduated from law school. Most birth moms have not. But even if birth mom can represent herself, even if birth mom is a lawyer, birth mom is something else. She's in labor. I'm not saying that a woman in labor can't simultaneously, while in labor, put on an evidentiary hearing and a trial. I'm just saying that while she does, she is also what? She is distracted, right? I've never personally been in labor. I've watched my beautiful Bernadette be in labor twice. Today, as I speak to you, is Madeline's 8th birthday. I remember as Bernadette was being wheeled in, and in labor, I said to her, thank you for doing this for our family. And I meant that, because if you've seen labor, getting choked up here, sorry. If you've seen labor, it's painful, right? It's hard, right? At a bare minimum, it's distracting. Imagine doing that and conducting your own evidentiary hearing or trial at the same time. That's what these procedures require of birth mom. If she can't, on the spur of the moment, reach a private lawyer and have the money to hire him and pay him whatever he wants and get him to come out there right then and there. How's that for due process, huh? So that's why I include this case. And under the notes and questions to consider, I give you some things to think about. I'm on page 215, note 1. How may the state of Florida respond when a pregnant mother exercises her right to refuse medical care? Consider the following excerpt from the spring 2013 issue of the William and Mary Journal of Women in the Law in Mark Bonner and Jennifer Sheriff's article called "A Child Needs a Champion, Guardian Ad Litem Representation for Prenatal Children." And what I quote you now is on page 216. It's from 19 William and Mary Law Journal of Women in the Law, beginning at 511. Printed in 2013, quote, "When should the legal status of a prenatal child be recognized as being the same as that of a newborn infant? Many courts have compelled pregnant women to submit to medical care, such as blood transfusions and cesarean sections, to protect the health of their prenatal children." Continuing the quote, "In the case of Pemberton versus Tallahassee Memorial Regional Medical Center, Inc., a pregnant woman was ultimately forced to have a cesarean section after multiple physicians concluded that vaginal birth posed a substantial and unacceptable risk of death to her child. Notably, Miss Pemberton had delivered her previous baby by cesarean section in 1995. When Miss Pemberton became pregnant again in 1996, she was unable to find a physician who would allow her to deliver vaginally. Consequently, she attempted to deliver her baby at home, unattended by any physician and without any backup arrangement with a hospital. And don't think of this, as I diverge here from the quotes of the article, don't think of Miss Pemberton as some sort of rogue person. Indeed, this vaginal birth after cesarean, or VBAC, as the physicians call it, is something for which in most jurisdictions, the insurance company won't provide you with insurance coverage. If you're an OBGYN or a physician and you want to do a BVAC, you can't be covered. You won't have insurance for that reason. Most, if not many, physicians will turn down a request for a VBAC simply because they wouldn't have the required insurance to perform it. So when you read here that Miss Pemberton couldn't find a physician to do the VBAC, don't think it's because Miss Pemberton is evil. Think of it perhaps being because the doctors financially couldn't do it for lack of insurance. I go back to the quote of the article now. Quote, after more than a day of grueling labor, Miss Pemberton decided to go to the emergency room to request intravenous fluids. A board-certified physician advised Miss Pemberton that she needed to have a cesarean section, but she adamantly refused and left the hospital against medical advice, apparently surreptitiously. I go off script again to point out, she snuck out. This is a strong and brave woman. Never met you, Miss Pemberton, but I respect you. Getting back to the quote. The hospital called an attorney, who in turn contacted the state attorney, at which time a special assistant was deputized to handle the legal controversy. Off script, listen to this procedure. This is the procedure I was telling you about that is followed in Florida. Listen well as the procedure continues. Quote, shortly thereafter, a judge visited the hospital to conduct an emergency hearing. Multiple doctors testified that the vaginal birth would pose a substantial risk of uterine rupture and resulting death of the baby. After ordering Miss Pemberton to return to the hospital, the judge continued the hearing in her room. Remember, she's in labor. And afforded both Miss Pemberton and her husband an opportunity to express their personal views. Oh, well, gee, thanks. At the conclusion of the proceeding, the judge ordered that an emergency cesarean section be performed, and Miss Pemberton delivered a healthy baby boy with no complications, end quote. Do you think Miss Pemberton agreed with the ruling? No. What about the right to appeal? Well, you remember from a prior lecture in our class, there's no constitutional right to appeal. More than that, there's no practical way to appeal here, is there? She was ordered back to the hospital. Her and her husband were allowed to express their personal views. I don't hear anything about an attorney. She didn't have a right to appointment of a free attorney, that's for sure. And then we hear an order is made right there in the hospital she's been ordered to return to, and she's ordered to undergo the cesarean. I guess tomorrow or the next day or next month or next year she could file an appeal, but the cesarean is done, and it can't be undone. So this is what we call a constitutional right to due process under Florida's Constitution. Note 2, I'm on page 216. Both the Burton case, whose opinion is reprinted above, and the Pemberton case, whose facts are described in the Law Review article excerpted above, were an action that was initiated in the circuit court by the state attorney under the procedure described in Re Dubreuil. You'll find that at 629 Southern 2nd 819. It's a 1994 decision of the Supreme Court of Florida. As provided in Dubreuil, after the state attorney received notification of a healthcare provider, that a patient refused medical treatment, the state attorney exercised his discretion to determine that a sufficient state interest was at stake to justify legal action. Perhaps the intent was to afford procedural due process protection to the pregnant mother's fundamental right of privacy in her decision to decline medical treatment. But would the typical pregnant mother subjected to such procedures, be in any condition to defend herself in an unannounced, unanticipated court hearing? What do you think of the dissent in Burton and its argument for a right to counsel for the pregnant mother? What do you think? I think it's clear from the way I've presented the case what I think. But this class isn't about what I think. It's about what I think insofar as that's how I present the material. But I present the material in this way, first, because I'm a lawyer. We take positions, we take sides. And second, because I want to be entertaining. I want to try to keep you awake, despite the fact that I've got nothing but some old dusty law books behind me. And third, because I want to spark in you an interest in this material. What do you think? I'm interested in hearing that. One way you could express it is in our next class when we meet together. Another way you can express it is that this might be an excellent topic for your graded essay regarding subsidiarity. Here we have two sovereigns, do we not? We have mom and we have a second sovereign. We have her baby. Who should be making the delivery decision? Well, certainly the baby's deciding it's time to be born when the baby makes that decision, right? But a third sovereign has reared its head, the state of Florida. How does subsidiarity apply here? How should it apply? I'd love to hear that from you. Note 3, I'm on page 217. Perhaps another intent of these Dubreal procedures was to give a measure of protection to the needs of the unborn yet viable child? ? If so, does the child have a sufficient advocate in such proceedings? Or would a guardian ad litem be appropriate? ? On that point, consider by analogy the 1989 holding of the Supreme Court of Florida in an abortion parental notification case called In Re TW. You'll find that if you're interested at 551 Southern 2nd, 1186. It holds that the lower tribunal erred in appointing a guardian ad litem for the pregnant minor's unborn child. So, when it comes to those three sovereigns we're looking at here, the state of Florida, mom, and baby. State of Florida has all the legal assistance it could possibly need, right? State of Florida has a state attorney on the payroll who by statute takes these calls 24 hours a day, 7 days a week, work day or not work day, weekend or not weekend, holiday or not holiday, rain or shine, 24 hours a day, 365 days a year. Also, the chief judge is supposed to take the state attorney's call, send it herself or himself or one of his or her judges in the circuit out to the hospital to hold this hearing right then, right there. Weekday, weekend, holiday, doesn't matter. That's the power the one sovereign has. Look at the power the other sovereign has. She can try to get on the phone and find herself an attorney. She may or may not succeed. That hearing's happening right now. No free attorney for you, Mom. No constitutional right to counsel. But I guess at least, as you saw in the Pemberton description, she can voice her opinion. Maybe even the husband, dad, can voice an opinion. What about the third sovereign? How's the baby who's on its way supposed to voice an opinion? How's the baby supposed to be heard? Right to counsel? No. In Re TW holds the baby has no right to counsel. Guardian ad litem? No. In Re TW holds there shall be no guardian ad litem. What do you think? Is it fair to call that due process? Is that a proper implication and application of subsidiarity? Again, I would love to hear your thoughts in the graded essay if you choose to make this your topic. Choice is yours. The next up, we're talking about Florida's right to privacy and something that's euphemistically called assisted suicide. In Florida, is there a constitutional right to suicide? Spoiler alert, the answer is no. Florida's Constitution and its Declaration of Rights, Article 1, Section 23, and its textual right to privacy has not, NOT, not been interpreted to mean that a Floridian has a constitutional right to assisted suicide. We know that from the case excerpted in the book, Krishner versus MacIver, a 1997 decision of the Supreme Court of Florida. It is worthy of us taking the time to explore it more, just as the remainder of Chapter 6 is worthy of further discussion. I've been very blessed with your help this semester to have not fallen even a moment behind the syllabus. We're scheduled to cover Chapter 6 today, and indeed that's what we're covering. Maybe we're scheduled to finish Chapter 6 today, but we are not. These topics are worthy of our further discussion and should not be given short shrift, in my opinion. So coming up, when we continue and we meet again next week, we'll be looking at Krishner versus MacIver. We'll be looking at Florida's right to privacy and suicide. We'll be looking at the notes and questions to consider, which in turn ask us to look at some very meaningful things that are worthy of our discussion. Until that time, I wish you well. The midterm that I've written for you has been approved. I think it's a good midterm. As I mentioned when we met last, I prefer an essay exam. I am instructed to provide you with a multiple choice midterm. I shouldn't preach on subsidiarity and not practice what I preach. I respect those who tell me that the midterm should be multiple choice. I've written a multiple choice exam. Is it hard? Yes. Should you study? Yes. Should you study well? Yes. In today's lecture, we covered Chapter 6. I will not cover Chapter 6 on the midterm. We have covered Chapters 1 through 5 prior to today. I will cover Chapters 1 through 5 on the midterm. It consists of 20 or is it 25? Multiple choice questions. I'll get back to you in the exact number. And in so doing, I believe I've drafted an exam that will help differentiate the A's from the B's from the C's from the D's, and the D's from the F's. As you know, there is a required curve to be applied at the end of the semester. Because of that, only a maximum number of students can receive an A, regardless of how many I might feel are worthy of an A. So based on that required curve, I think it's wise to give challenging graded projects such as the essay, such as the midterm, such as the final. Because if they're not challenging enough, then that curve does an ugly thing. It takes a big group of people who mathematically could be entitled to an A, and it assigns some of them B's or C's or, gosh, maybe even worse. So if you want an A on any of my graded projects, whether it's my midterm, the graded essay, or the final exam, you better study hard. What do I mean by study hard? I'm not looking for you to regurgitate my opinions. As best I can tell, and of course we all have internal biases that we fight to overcome, as best I can tell, I'm not testing you on my opinions. I am testing you on the material we've studied, but in such a way that you need to do more than just memorize and repeat. I call the text Analyze Florida's Constitution, and indeed that's the level of understanding I need you to be at. I need you to analyze the words and the material and the laws and the case law precedent and the other sources that are presented to you throughout the semester. So you need to get beyond just memorization and get to application. If you can apply what I've lectured and written about, then you have a better chance of getting an A on this exam. One of the things that I find helpful, and all of us are different, so it may be different for you, but one of the things that I find helpful back when I was a law student and today when I'm preparing for oral argument and an appeal or a negotiation with an opposing counsel are drills, if you will, hypotheticals, if you will. You've seen me stop many times during a lecture and take a rule of law and come up with a fact pattern and then ask, how does this rule of law yield a result under this fact pattern? In my opinion, that's an excellent way to study in such a way that you can get beyond mere memorization and on to application. I find that helpful when I studied for an exam in law school. I find it helpful when I prepare for an oral argument. You never know what judges are going to ask you from an appellate court bench. So I look at the facts. I think, what if they asked me this? What if they asked me that? When I'm negotiating with an opposing counsel, I'm never quite sure what elements of the negotiation are most valuable to them. I think to myself, what if they can't give up on this point? How can I still get to a resolution? What if they can't give much on that point? How can I still get to a resolution? So I think it's a great way to teach a law school class to require the students to go from memorization to application. Because what I've found in 25 years of practicing law is that's what I do. I move from memorization to application. So I think it's worthwhile to ask my students to try to do that now because in my experience, that's what they're going to have to do later when they practice law. So beat the rush. Do it now. Take the material that I've taught to you and drill yourself. Ask yourself, okay, what's the rule of law? And memorize the rule of law. But don't stop there. If you stop there, you're going to do very poorly on my exam, and respectfully, you're going to do very poorly as a lawyer. You have to get beyond memorization and into application. You got to know how to analyze. So do it now. Beat the rush. As you study for the exam, of course, memorize the rules of law, but don't stop there. Keep asking yourself, well, what about this particular fact? Try to dream up some facts and then apply that rule of law and try to dream up an outcome. Sometimes that's best done in the privacy and the quiet of your own study. Sometimes it's best done by bouncing ideas off of other people. However you do it, because you're going to need to in order to excel in this class and, in my humble experience, in order to excel as a lawyer. So those are my parting words of advice, not only about that test called the midterm, but that test called life. Lawyer's life, that is. I hope that advice serves you well, just as I hope my lectures and my writings have served you well. Until we meet next week, stay safe, stay healthy, and may God continue to bless us all. Thanks for taking my class. What? You're still there? Class ended. Go do something better with your time. See you next week, y'all.